Hello, I'm Timothy Wiseman, and today I'm going to discuss the Streisand effect, what it is, and how it can affect the decision to pursue certain types of litigation. In its simplest terms, the Streisand effect is the observation that some efforts to suppress information can sometimes have the opposite effect. In other words, attempting to suppress information or commentary, especially on the internet, can sometimes draw more attention to that information than it would have received otherwise. This has been noted as creating a potential dilemma for possible litigants in certain types of cases, including defamation cases. The term was first coined by Mike Masnick of TechDirt while discussing Barbra Streisand and her attempts to suppress pictures of her house, in particular, this picture. In 2005, Mike Masnick coined the term the Streisand effect in an article discussing another case. That article referred back to his own earlier 2003 article in which he discussed the lawsuit by Barbra Streisand over this picture. Barbra Streisand was trying to have this picture removed and suppressed. Before she filed the lawsuit, there was very little attention to this picture. It had been downloaded only a handful of times, more than one of those by her own attorney. After filing the lawsuit, the picture gained notoriety and became worthy of comment in a way that it hadn't been before. It was because of her lawsuit that this picture became famous and frequently discussed. As another example, Representative Devin Nunes attempted to sue the anonymous person behind the Twitter account Devin Nunes Cow. Before he filed his lawsuit, the account had approximately 2,000 followers. After he filed his lawsuit, the lawsuit itself gained attention and notoriety, and the number of followers for the Twitter account went up dramatically. It went up within a span of a few days to over 454,000 and continued to climb. As you can see from the image, I'm one of the followers. I first learned of this account personally because I read of the coverage of this lawsuit on TechDirt. As another more business-oriented example, there was the case of Casey Movers. As the name implies, Casey Movers was a moving company. One of the customers left a relatively negative Yelp review regarding Casey Movers. Casey Movers proceeded to threaten to sue the reviewer. Her husband took offense to this. He drafted a blog post. His blog post then gained the attention of the press. Among others, The Consumerist and TechDirt wrote about this, and the attention of the press caused the original negative Yelp review to gain far more readers, far more attention than ever would have. The conclusion here is that because of the Streisand effect, there is often a dilemma in filing a lawsuit that seeks to have speech removed. This is particularly common with defamation suits, so that's certainly not the only context that it can come up in. It can also arise in a breach of non-disclosure agreement. At any time when considering filing a lawsuit that seeks to have speech or communications removed from the public view, it runs the risk of drawing more attention to it than it would be. In some cases, especially if the speech is already notorious and widely known, this risk can still be worth it. However, it does create a dilemma, especially if the speech in question would otherwise be relatively little known. If you have any specific questions about this topic, you should contact a licensed attorney in your local jurisdiction. Thank you and have a good day.